Hey y'all, I'm Ada Kay, and I must confess, I'm a trial junkie. I enjoy viewing trials as if I was the seated juror. So grab a cup of java, get comfy, and join me as we hop into court. And don't forget to comment, like, and most importantly, subscribe. And if you're really enjoying the channel, please join our membership. Good morning, y'all. Well, do you know what I left off my radar? Yep, we have a Supreme Judicial Court hearing for the Karen Reed. So I'm not going to BS around. We're going to go ahead and hop on in and get going because guess what? We're running a little bit behind. My bad. And let me get it going. Good morning, everybody. Thank you so much for joining. I apologize. I only got 3 hours sleep. How about you? It was a long night.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Supreme Judicial Court, now sitting in Boston within and for the Commonwealth, draw near, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. Court is now in session. Please be seated.
Okay, good morning.
SJC 13663, Commonwealth versus Karen Reed.
Good
morning, Chief Justice, Associate Justices Martin Weinberg on behalf of the appellant Karen Reed.
Fix your hair, dude.
Today's appeal goes to the core issues regarding double jeopardy protection that safeguard defendants, in this case, Ms. Reed, from the risk of re-prosecution for the very same offenses for which a prior jury was discharged without manifest necessity, without her consent. And we now know, based on the representations of 4 jurors, indirectly a 5th, no contradiction from any of the 7 or 8 other jurors, that there is a trustworthy, corroborated, and we contest uncontradicted showing that the prior jury reached a unanimous decision to acquit Ms. Reed of 2 of the 3 charges in a multiple count indictment that she was tried on in Norfolk County. I want to first...
What is the factual basis for your assertion that the jurors who contacted the DA's office are different people from the ones who contacted yours?
I don't have a basis to...
Okay, so when you say 7 or 8, that's speculative?
The numbers are that 4 of the jurors directly contacted the defense. A 5th, there was indirect proof that a 5th juror contacted the defense. A juror who could have been one of the 5, could have been one of the 7.
Okay, so you're not representing that it's more than 5?
That's correct.
Okay.
What I am contesting is that there was no manifest necessity for the mistrial, which is issue 1. There was no consent, issue 2, and that this court's jurisprudence strongly suggests that the defendant has met her burden of production and is therefore entitled to a post-trial jury voir dire by the trial court, at which we contend the probability, if not the certainty, that that voir dire would result in proof that there was a final and binding...
Mr. Weinberg, you jump all the way to acquittal, correct?
Yes.
Under Rule 27, the verdict has to be unanimous.
Yes.
It has to be a general verdict returned by the jury to the judge in open court. And then the second element, the jury has to file a verdict slip with the clerk upon the return of the verdict, which is a written recital of that same verdict. Here, none of those elements were met.
Correct.
The judge wouldn't permit
In
it.
the face of the juvenile case, in the face of Taylor, how is this an acquittal?
It's less a matter of labels. I could call it, Judge, a unanimous
Well,
decision.
you cite Taylor, which is the case in Quincy where the judge, basically there was a procedural defect in a complaint, and the judge, for lack of a better term, pulled the plug on the case, and we had to decide what was that. Was that procedural error, or was it a judgment on the merits? And we decided whatever the judge said, it was a procedural error. That case is an opposite to what this situation. So how do we say it was an acquittal without a verdict in open court and no verdict slip?
I think you say that there was a unanimous decision made by the jury that is subject to the proof that would come from a post-jury voir dire. I don't contest that this court should just impose an acquittal and substitute a verdict because of the declarations.
Well, that's a double jeopardy claim, right?
Yes, it's at the core of double jeopardy that if we can prove, and I
This isn't
suggest
going
we've
well.
more than met the burden of production of proof, more than
Morning,
many
Mary
cases
Kay,
where
Brony,
this
and
court is
Casey.
remanded for jury voir dires. That if that jury voir dire established, which is what we contend it would if ordered, that this was a final and unanimous decision made by the jurors, but they didn't announce it.
The post-verdict inquiry is usually or exclusively limited to extraneous information in front of the jury, charges of racism in the jury room, etc. Here, do you want us to carve out a new exception to that rule?
I think it's an extension of prior precedents. Fiddler talks about not establishing inflexible rules that would expense justice at the price of certitude. In Fiddler, there was evidence from the jurors that there was evidence received by a jury that didn't come from trial evidence. So that was.
Doesn't Fiddler caution to not inquire into to intrude into the sanctity of the deliberative process as well?
It does.
Absent this extraneous influence. But the influence in this case is not extraneous. It has to do with the very deliberations that occurred, correct?
I would argue that it has to do with the results of those deliberations, and that a carefully set of questions preceded by an instruction to a voir dire jury. We don't want you to disclose why you reached a result or the content of your process.
Are you kidding? You're public.
We want to ask you about a result. Did you vote on count one? How did you vote?
You seek to impeach the written communication by the foreperson, correct?
I'm sorry, Judge.
You seek to impeach the written communication of the foreperson, correct?
I would say that the recent jury declarations demonstrated that there was facial ambiguity in those communications. Yes, they related to a lack of unanimity, to a deadlock about charges. But count two by itself, read vertically, had multiple charges. Horizontally, there were three separate counts. There was ambiguity. The trial court didn't realize it. The trial court erred in not allowing what Taylor and Stewart mandate as imperatives before there was a ruling of manifest necessity. No opportunity for a defense lawyer to make arguments about options to the declaration of mistrial, and I contest that there were at least three viable options that Stewart, Taylor, and all the cases of this court mandate be, quote, carefully considered.
You've got an exhausted jury writing this very eloquent message saying, we haven't been, we've done our best. We haven't been able to reach a verdict on any of the charges. There's no inkling in that they've reached verdicts on charges, or that this only relates to the second charge, right?
Facially, there was the words charges and the words in deadlock.
What's going to happen with this motion for new trial, right? Everyone thinks the jury's done its best. It's exhausted. It's tried every option, and everyone's resigned to trying the case again. I understand something happens later, but at least at that point, is it really a mistrial? I mean, is there an error to declare a mistrial?
I would respectfully disagree that everybody concurred that there was only one reading of this note when the defense had no opportunity despite the clear jurisprudence mandating that they be given an opportunity to be heard.
Did the defense have an opportunity when there was a discussion about scheduling after the jury was sent into the room?
Once the judge
Ouch.
discharged the jury, once the judge thanked them and said that the case is over, the failure to make an objection was futile. It was unnecessary.
What about the case of Como versus Enid Brown, where the jury was sent, the jury goofed, essentially. There was a miscommunication between the clerk and, you know the case. The jury was discharged, sent into the jury room, and then we said it wasn't error to bring the jury back after discharge to clarify the verdict.
And had the jurors that signed that, or that made these representations starting the very day after the announcement of the mistrial, if they had told the judge.
I guess the point I'm asking Mr. Weinberg is, there was a time period, and I get your point that it was hasty to not have consulted with the attorneys before bringing the jury in. But be that as it may, after the discharge of the jury, I'll talk to you later, as most judges do. The lawyers then talk about a scheduling conference and timing of it. Wasn't there an opportunity at that point for the attorney to object and say, this is what should happen, these are my thoughts?
There was an opportunity, but not a responsibility. The law in this case, starting 39 years ago, was Stewart, places the heavy burden on the Commonwealth, which wants to re-prosecute a citizen in the face of the decision of the first jury, to recommend alternatives to the judge. And the trial judge found consent, in part based on the failure to make an objection.
And I think we cut you off when you said there were three things that could have happened. Could you please tell us what those are?
Yeah, one is the trial judge receiving this note, and remember, didn't read the note to the defense, didn't give them an opportunity to be heard, said, bring the jury in. The jury comes in seconds later, 30 seconds if the court were to look at the video, which has been relied on by my brother as well as the trial court. The judge could have said, I've received this note. Does it relate to all or just some of the charges? That's not a coercive question, and there's no capacity.
Good morning,
to coerce,
Sonia.
the jury into redeliberating. It would illuminate the implied ambiguity, which is illuminated by the jury declarations, that there were two ways to interpret the note.
Don't you think we're supposed to assess the judge's decision-making or thinking in the context in which it occurred, which includes two previous notes reporting impasse? You argued very forcefully below that the jury had reached an impasse and for the Tui Rodriguez charge to be given. I'm assuming you made that argument in good faith.
The argument was made in good faith.
Yes, and there was no information intervening the second time you made that argument, no additional information about the jury's thought processes between that second note and the third note.
I would respectfully suggest that when a defense lawyer asks.
I'm not asking for an argument here. I was going to ask you for a reference to the record to indicate anything that happened in between the third note, the second note, and the third note.
Yes.
That would indicate any less of an impasse between the first, second, and third notes.
Yes, what happened is that.
I'm just looking for a record site.
The record is the jury went out and deliberated for several hours, subject to a TUI instruction, which is designed to encourage a jury to reach a verdict when they declared an impasse.
Right, so I understand your answer to be there's nothing in the record to indicate that they were at any less of an.
They're not
impasse
gonna
than
win
when
this.
you sent the second note.
No, and I would contend that all three notes are ambiguous. The defense.
That was not the argument you made below.
The argument made by trial counsel was to argue not for a mistrial. They never asked for a mistrial.
I understand, but there
They
was
asked
no
for-
argument that these notes were ambiguous down below, correct?
Down below at the trial court, yes, the argument made on the motion to dismiss was
No,
that there
at the
was ambiguity.
time, not at the motion to dismiss, at the time.
They had no opportunity at the time to.
First note, was there an argument made concerning ambiguity in response to the first note reporting impasse?
No, there was a
Was
request
there
for
any
TUI.
ambiguity argument made in response to the second note?
There was a request for TUI. But the
Right.
only time that I suggest matters is the third note where they had no opportunity to make that argument.
Why would that be? Why would we just focus not on the totality of the three notes, but just the last note? Why is that, in your opinion, or actually citing any legal authority, why would that be the critical moment?
Because before that, there's at least an impasse on one count. And there is no obligation on a trial court in terms of timing when to seek a partial verdict. When Judge Descasiano asked me for what the three alternatives are, one of the alternatives was simply to ask the jury what it meant. The second was to apply Rule 27B, which says before a mistrial, a court may request of a jury whether or not they've reached any decision on any of the other counts. The reporter's
What,
notes.
at the moment of the declaration of the mistrial, what suggested in the
Hello, Rich?
notes, the three notes, that there was any agreement as to any?
He's not gonna
of the
win
three
this.
charges?
At all.
They said
Nothing.
they were at an impasse, and the court has an obligation to carefully consider all alternatives under Taylor and Stewart. There's no evidence on this record that the trial court made that consideration.
Well, after the first note, she asked counsel and the prosecutor, what do you think? And I thought defense counsel argued they've exhausted their review of the evidence. And so give the Tui Rodriguez, and the prosecutor said, not yet. And she said, yes, no, not yet. And then there was the second note where again, they report that they're in an impasse quite eloquently. And again, at that point, the prosecutor says, don't give the Tui Rodriguez, and the defense counsel says, yes, go ahead and give Tui Rodriguez. And she considers that alternative and gives the Tui Rodriguez instruction. Now we have the third note.
Rodriguez is what I was
We've
looking for
really
the other day.
tried on all the charges. Some of us agreed that beyond a reasonable doubt, that the elements of each of the charges have been established. Some of us do not. And at that point, she's considered the alternatives. Let them continue to deliberate, give the Tui Rodriguez, and the third time, it sounds like that everybody's in an impasse. That's all the information she has.
And that's part of the perils of not providing counsel with an opportunity to be heard, which is what was required. Because we don't know that the jury notes 1 and 2 didn't also relate to one rather than 3 counts. What the defense wanted was a verdict.
I'm doing it backwards,
If you want a
guys.
mistrial, you ask for
So
one.
your
They
rule
asked
would
for a
be
TUI
that anytime there's more than one charge, the judge must ask, when the jury reports back that they're in an impasse, the judge must then ask, well, are you at an impasse as to count 1? Are you at an impasse as to count
Yep.
2? As to count 3? That's the rule?
When there's a multiple count indictment, that's the rule as described by the reporter to 27B, which is a trial court must make that inquiry before ordering a mistrial.
I thought there was a may, which the one where.
The may was in the rule, the reporter's note says must. I would argue the may relates to timing. In other words, there's no obligation of a judge at any particular time to ask the jury whether there's a partial verdict. But if you're going to issue a mistrial order, that's where the must comes in. And
In the ordinary case, the foreperson will say, we've got a verdict on counts 1 and 7, and we seal them, and then we continue on, and we can mistry the remaining counts, correct? When you say it wouldn't be coercive to ask, am I right to assume that you're relying on Rule 27B?
27B and the distinction in the Roth case, which is there is a risk of coercion if you're dealing with a single count with multiples. But 27B preempts that in terms of the importance of a mistrial order.
And your argument to Justice Wendlandt, and I guess to me as well in the court, is that that is not discretionary.
My argument is that given the core values of double jeopardy, that unless the defense consents to the mistrial order, the court has to comply with the guidance, the principles, the mandates of Stewart and Taylor. Here they complied with neither one of them.
And that's absent any other evidence as far as the deliberations go and the notes that there's an agreement, at least partial agreement on a particular verdict, correct?
Yes, those notes were subject to one of two interpretations, and given the obligation of a trial court to consider all alternatives, including the alternative post-Tui of seeing whether the jury wanted to deliberate on any one of the three counts, which is part of the statute. I think it's 268-34C. That's a third alternative. Here, the problem is the record doesn't reflect the trial judge's consideration.
As a matter
of
of
these
fact, were
alternatives.
there three separate verdict forms?
There was actually more than three verdict forms because the verdicts on count two had multiple, they had three
So
different options.
count 1 and 3, were there separate verdict forms for those?
I believe there was separate forms, but there was, guilty, not guilty, count 1, count 3, and count 2. There was supplemental instructions and an amended verdict form to make sure the jury had options that were consistent with the law of the SJC as to how you deal with lesser includeds.
Can I ask, sorry, so I'd like to ask the judge says she can't ask the questions that you're saying she could without interjecting herself into deliberation. So let me read what she says. While the defendant contends that the conflict is reflective of the fact that the instructions given to the jury by the court were confusing, determining whether this is true would necessarily require inquiring into the back and forth among the jurors during deliberations. Can you tell us how?
Yes.
Why? How would she do this? She doesn't envision a way that she could ask the questions you're talking about without requiring them to explain whether they took votes, how they took votes, what the votes were. Just tell me what your thought process is on that.
My thought process, one is that this court has the option of essentially informing the court what questions could be asked. And two, if we're going to delegate.
Require follow-up questions. And unlike extraneous influences where you can say, okay, we only want to inquire about whether there was a racist statement made or something to that effect. This is different. We're going to have to require what their votes were and how solid they were. Isn't that going to get into deliberations inevitably?
I think you could ask about the results of deliberations. I would design it by saying an instruction to the jury to not disclose the content or your processes of deliberation. But I want to ask you the following questions. One, did you take a vote on count 1? What was your vote? Was the vote unanimous amongst other jurors? Was the vote final? Was it ever reconsidered or rediscussed?
That question, is it final? Isn't that gonna, the jury can change its mind, right?
Could, but there's no way.
But isn't that gonna result in asking that type of question? When you say final, if you don't get your way on 2, is it final?
Was it ever reconsidered? My contention, based on these jury declarations, based on the voicemail, based on the fact that in this highly publicized case, no other juror, they served for months, says to anybody, to the court, to the clerk, to the court officers, to the prosecutor, wait, I didn't agree.
They also don't write in saying we agree with the other 5 or anything to that effect. They're silent, as their deliberations are supposed to be silent, right?
But it's an almost unprecedented meeting of the burden of production. If this was a Sixth Amendment issue, the jurisprudence of the court would compel a post-jury inquiry. The Fifth Amendment values are just as important. Questions can be designed, whether it's final or was it ever reconsidered, that would demonstrate what we contend. These were final votes. This was the end of counts 1 and 3. It's exactly what juror D says. We went to the bus and says no one's ever going to know that we voted to acquit.
Isn't that part of the problem? And isn't that what Bluford counsels against? Because you keep saying that whatever was done on counts 1 and 3 were fixed. And despite the fact that there was potentially still some uncertainty about where the folks were on count 2, that could never change in the continuing deliberation about count 2. And isn't that what Justice Roberts was talking about? The deliberations weren't finished, they weren't finalized, and you keep using that term. But there's still opportunity for folks to change their positions in the context of the continuing deliberations on count 2 and its lesser included. So what's your best authority to say that it was fixed for all time and for all deliberations, and there was no opportunity, particularly when we don't know that no one, to Justice Kafker's point, has called and said, hey, me too, we believe the same thing, for the court to say that this is what it meant for all time?
So, and the answer to the question, and I understand the question, in the Bluford case, we had the return under Arkansas law, which prohibited partial verdicts. The jury said that they'd reached a decision, they were sent out again, and then they said they had changed that decision and were at an impasse. In this case, a post-jury voir dire can ask about whether or not you took a vote. Was it unanimous? That doesn't intrude on the values of 606B. Was the vote ever reconsidered? Was it final?
But that's my point. If you stop right there and say that's the end of the inquiry, that's really not true, because there's still deliberations that are left on count 2 that might inform a juror's change of position on count 1 and 3.
And that could be the subject of a jury inquiry as to whether or not the unanimous vote that acquitted Miss Reed of murder and leaving the scene was ever reconsidered. You can ask for a result without probing into a mental process, into the content of deliberation. The values at stake here are too important. Yes, in the McCallop case, we allow a court to ask about mental processes. Was there communications of bias? In Fiddler, they talked about the communication of evidence that wasn't received through the gatekeeper function of the trial court. This is important. Miss Reed was acquitted by those jurors, and we should have the opportunity, or not acquitted, we contend, a unanimous vote. We should have the opportunity to have Judge Cannone conduct a voir dire. It's done when one juror says there was a statement of bias, when one juror says there was contact with an external source.
Right, but when it's an extraneous source, then you need not get into deliberations. But as I listen to you suggest questions that the trial judge could have asked, it seems to me those questions go directly to the jury deliberations.
And I would contend they go to the results of the deliberations. They do not require a judge to ask, why did you vote not guilty? What led you to vote not guilty?
So the question asked to juror F would be, was that vote final?
Yes.
Juror F's answer would be, well, no, it kind of depended on how I would have voted on count 2. We were not yet done.
And that would reflect two
The
things.
jury deliberations, right?
That would reflect that the voir dire by the judge did not lead to a result of a final unanimous verdict of not guilty. But to foreclose those inquiries when there's a real possibility 12 jurors are going to say to Judge Cannone, if conducted, that was my vote, it was not guilty. We never reconsidered it. We considered her innocent. We didn't think she intentionally killed anyone. We should not be foreclosed from having that option.
It seems to me that what you are in effect asking via a post-trial inquiry is to discover whether the jury disregarded the jury instructions. And the reason why I say that is that the jury were instructed to return a verdict after the final vote, and I'm using that as a direct quote of the jury. So when they had a final vote, they were then to check the appropriate boxes as to each charge, then sign and date the verdict slips. And it seems to me, or at least please correct me, why isn't this post-verdict inquiry that you're suggesting actually an attempt to try to establish that the jury didn't follow the instructions? We have a long line of jurisprudence that says we presume that the jury follows the instructions.
And there is cases where, when mistakes are made by jurors, where they don't fill out the verdict slip accurately. The Capen
That's not
case.
this case, though.
No, this case, I think, is a stronger case for a voir dire because we're not impeaching a verdict. We're explaining a note. We're asking the jury to resolve an ambiguity within the note that the trial court didn't realize, in part because they didn't provide an opportunity for argument, in part because they used a procedure that's totally at odds with this court's jurisprudence in Stewart and Taylor. And before we get to the voir dire issue, we contest there was no manifest necessity. And
before you shift back to that, what's the best case? That's federal, because we're interpreting federal law here. What's the best, closest case, and not an extraneous influence case, allowing this type of probing after? If we want to go back and read
Wow.
one case to do what you want us to do, but what's the closest case?
It's actually a Mississippi case. I think it's named Martin versus State, that the amici brief brought us to, where they read the
It's a state
newspaper.
court case, right?
Yes, it is.
Any federal cases? Because again, this is a federal constitutional issue.
You know, there are cases where jurors correct verdicts.
No federal case
This is,
that has the, you're asking us to direct Judge Cannoni to do this. I just would be helpful if you have a federal example that we can turn to, because we're interpreting federal law, not our own law here.
this court has a long history of applying
We don't
federal
have any
constitution.
cases except extraneous.
He doesn't know.
I'm just again, your chance.
Can't answer.
Best case that we should look at for you.
You do have one example, which is the McCallum case, which follows a Supreme Court case and allows the jurors to disclose their deliberations regarding ethnicity and racial bias.
Again, extraneous influence, that's different.
It's internal to, I think it's closer to the core of 606B.
Again, no federal case we can turn to, for example.
Nor has the prosecutor come up with any case to the contrary. This showing by this jury, it's not going to open the floodgates for post voir dire.
Well,
This is-
actually, that was my question. What's the limiting principle here? It sounds like if ever a juror comes back to the defendant and says, hey, that's not really what happened, then we open it up.
This would not be a case where a juror has second thoughts, is reconsidering, didn't think she was, he or she was listened to in the jury room. These are representations by 4 jurors that were unequivocal, unconditional. They said we reached a final verdict of not guilty, and
So the jurors submitted affidavits?
The jurors would submit affidavits. If we asked the judge, if you're not going to accept the lawyers' affidavits, please authorize the lawyers to go back to the jurors. But we didn't want to walk near the boundaries of 606B. The judge accepted the truth of the lawyers' affidavits as a substitute for the jurors' affidavits. But again, let us voir dire the jurors. The judge has the power to make a decision. Was there a unanimous verdict of not guilty?
But our review is an abuse of discretion. Why was it an abuse of discretion for her to deny you that ability?
Because the Stewart case says the deferential appellate review depends on whether or not there's proof of compliance with the principles set forth in Stewart, meaning, did the judge carefully consider all the options? Did the judge give the defense a full opportunity? These were mandates, not discretions. They're conditioned precedent to the declaration of manifest necessity. It simply wasn't followed in this case. It wasn't followed the basic rules, Floyd P., which is when a jury gives a note, you share it with counsel, you listen to counsel, you get their views. We don't know whether counsel would have advised the judge about 27B, or would have asked the judge to ask the jury whether to...
Counsel, can I go backwards on that?
Sure.
Because part of I don't know what part of this goes into the calculus, but you have 2 extremely experienced trial lawyers. No one in that room would ever think, potentially, a mistrial may be declared after Tui Rodriguez is given. There isn't any lawyer that's worth their salt that wouldn't think they might get a mistrial on this. So you know where the puck may be going when it comes to giving to Tui Rodriguez. And you say that there was no manifest necessity for this and no opportunity to be heard. How do we factor in that you've got to know that that's going to be on the table, is that a mistrial? And what obligation is there on counsel to say, hey, before you declare a mistrial, let's talk about alternatives to that?
So let me address that. Judge comes in, deviates from her prior practice where she gave counsel a full opportunity, announces to the defense lawyer, there's an impasse, bring the jury in. If your honors, would accept the audio video that, again, the district attorney has relied on, it's about 30 seconds till the jury comes in, but you hear a door open. Defense counsel don't know what's in the note. It hasn't been read to them. They don't know what the judge's intentions are. They don't know whether they'll be invited to come to the bench to discuss.
That's right. He
They
wasn't
have to be
there.
surprised they weren't given an opportunity. They hear a door open. The jury could come in 5 seconds, much less 30. And I stand before you with 52 years of trial experience to say no competent defense lawyer would risk the wrath of a judge or jury by interrupting that process, by making objections. So
The judge said they're at an impasse, bring in the jury.
bring in the jury and you can actually hear a door open.
Okay,
So
and you have 30 seconds to object.
But you don't know that it's not 5 seconds. You don't know the door's not open. You don't know the
You
jury.
can't say,
can't
Your
hear.
Honor, may I see you at sidebar?
In this case, that's happened repeatedly? No?
Here, the defense lawyers.
Woo, they're tough,
know
y'all.
what the judge's intentions.
People are missing out by
They
not
know-
watching
But they
this.
did know that the jury had reported to her that they were at an impasse.
They were an impasse, bring the jury in. Yes, that was possible, but to
What was
extinguish,
possible?
to ask to go to the bench, but
Yes.
this
And
court.
did that happen?
No, but neither did it happen that the prosecutor, who this court says has a heavy burden because they're the sovereign, they want to re-prosecute somebody after a mistrial, to subject them to the perils of a second prosecution. The trial court did not impose a burden on the prosecutor. They have more of an obligation in double jeopardy law to raise options to a mistrial. And I don't think it's fair to conjecture consent or to penalize a defense lawyer when they have been relying on a procedure that's lawful, where defense lawyers have a full opportunity to be heard. They don't know what's in the note.
She doesn't need the consent of the defense to declare a mistrial. She needs to determine that there was manifest necessity for a mistrial,
After a
correct?
careful consideration of all alternatives and after giving the
That may
defense an
explain why
opportunity.
perhaps the judge did not inquire, was because given, I don't mean to replow the same territory, but this was the third note.
It was the third note, but it was a note that demonstrated, because of the deliberations between the second and third, that the defense didn't want a mistrial. They wanted a verdict.
Mr. Weinberg, are you aware of any cases, or can you let me know if there are any cases where the judge gives TUI,
Yep.
and then the jury comes back and says, we're deadlocked, as articulate as this jury was or not, and then the judge does something different other than just declare mistrial?
Well, the statute itself says the judge has no right to obligate the jury to redeliberate, but every right to ask the jury whether they would consent to continue deliberations. And here I
But
contest.
here, the jury said to continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs.
Right, and in the face of that, do you think give it the old college try is okay?
I think that the judge had alternatives that the record does not reflect, were carefully considered.
He is
including,
losing this battle,
is
y'all.
your deadlock on all three counts? Is there any, would you consent to deliberate on any count that you've not reached an irrevocable deadlock? Questions like that are not coercive. Questions like that would have actually given the illumination post July 1, and I'm not arguing that that provides proof as to what the process was on July 1.
And the statute, again, is
Yeah.
a may, correct?
The statute says 27B says a court may make that request, but the Stewart and Taylor rule require careful consideration. That at minimum was an option not considered.
The careful consideration is basically all that has gone on as far as the length of deliberations, a number of notes, et cetera, and what the notes say. That's part of the calculus, correct?
Yes, the judge made her own judgment, and I'm not saying the judgment was irrational. I'm saying that she would have been aided by counsel. The law required she give counsel an opportunity to be heard. There's no evidence in the record she considered any option except to declare a mistrial. That contradicts the clear jurisprudence of this court, and I contend it contradicts the core protections that double jeopardy give to a defendant against being re-prosecuted, which the Supreme Court has said carries with it the risk that an innocent person can be convicted, the ordeal of a second prosecution. This court has given procedural guidance, conditions precedent. This is what the words are must. 27B may be discretionary, although we argue the reporter's note in combination with Taylor required that inquiry about partial verdicts. This court has told the judges ordering a mistrial is irrevocable. And you need to go through certain procedural conditions precedent, and the judge did not. And I respectfully submit that extinguishes the principal basis to say there was manifest necessity in this case. There was never a knowing and intelligent consent. The defendant never asked for a mistrial. And at minimum, secondly, we strongly ask this court to extend the Sixth Amendment jurisprudence where you allow jury voir dires into the Fifth Amendment. The Fifth Amendment is as important as the Sixth Amendment, and a jury voir dire conducted by an experienced judge can determine whether or not there was a unanimous and final verdict of not guilty on 2 counts, one of which carries with it a life imprisonment. I thank you very much for the privilege of appearing before you today.
Thank you.
Wow, that was tough. Okay, here comes the prosecution. Let's see if they're going to be tough on them.
Good morning,
Wow,
Your Honors. May it please
that
the court,
was
Caleb Schilling.
frickin' brutal.
With me at council table is my colleague, ADA Laura McLaughlin. I'd like to start with
What do
this
y'all
trial
think?
issue and emphasize a point that has been touched on through the questions to my brother, but that I think is important for the court to consider, and that is the trial strategy here. As a general matter, absent some sort of definite indication from the jury that they're prepared to find a defendant not guilty on a charge, effective defense counsel is not going to ask the judge to start probing, or not going to want the judge sua sponte to do that, because doing so runs the risk of extracting a guilty verdict and convicting your client instead of obtaining a mistrial across the board.
But what do we do with the fact that after the third note, the jury is called in? There's not, unlike the first and second note where she says, okay, counsel, let me know what you think. Here, we don't have that opportunity.
The judge did inform counsel that the jury was at an impasse, and I would argue at this point, it is clear that a mistrial is inevitable or unavoidable. The jury has twice already returned deadlocked. The defendant has argued strenuously that they are deadlocked. They've been given to Rodriguez, and now the judge informs counsel they're at an impasse. At that point, counsel couldn't credibly believe that the result here was going to be anything other than a mistrial. And again, in addition, just to circle back, all the more so, Your Honor, because of what was their defense in this case. The defendant's defense was that she didn't cause the victim's death, but allegedly had been framed. If the jury were to come back with a guilty verdict on any of the charges, or either of the lesser included offenses, they would have necessarily had to find that the defendant did cause the victim's death. And it would have been a rejection of that defense and the defendant's public narrative. The defendant here did not want the judge to do more into it.
Rather than speculate what the defense wanted, let me ask you about what happened. Did the judge have either the discretion or an obligation to ask the jury after the last note about continued deliberations or a verdict on any lesser included offense?
No obligation, Your Honor. It perhaps is a matter of...
Did the judge have the discretion to do so?
Rule 27B is discretionary. the language of the rule itself consistently refers to what a judge or a jury may do. I know the defendant argues.
So it's not inherently coercive. If
So
the judge has a discretion, it can't be coercive,
It's,
correct?
well, no, it's a matter of discretion and then consider the factors that inform the exercise of that discretion. And that's what the judge did consider here. On the one hand, the judge had no doubt, based on the jury's notes, that they had not reached agreement on any of the charges. Further, the jury's third note had triggered 234A, 68C, so they couldn't be compelled to continue deliberating. They made it abundantly clear they did not consent.
Unless they want to.
Unless they wanted to, exactly. But indicated that if they were forced to continue deliberating, any verdict they returned wouldn't be a just verdict. It'd be the product of compromising their deeply held beliefs and moral convictions. You have that on the one hand informing the exercise of discretion. On the other hand, you have strong countervailing reasons that argue against making further inquiry here, which is the potential for coercion. You have a jury that has sat through a grueling 10-week trial, nearly 100 witnesses, hundreds of exhibits. Now 4 or 5 days of deliberations, they've returned 3 times indicating that they are deadlocked, they are at an impasse, and they do not want to continue to deliberate.
But counsel, I'm sorry to interrupt you on that because I don't want to miss this point. But wouldn't that go to the calculus of manifest necessity? Because all of those things seem to be the reasons why you would tell counsel about the last note and say, what do you think? Because you have gone through this 10-week trial. You have gone through the impanelment process. You've spent a lot of time, energy, and money, anxiety, and angst in this trial. Why, when we talk about what potentially we could do short of saying, mistrial, let's start again?
Certainly, Your Honor, and I think, in hindsight, seeing, the quote-unquote remarkable turnaround of the defendant's position, would it have been better, would it have been preferable for the judge to take that extra step? Perhaps, and another judge might have done that. But here, given the progression up to the third note, and in particular, given the defendant's response to each of those 2 prior notes, I think the judge could reasonably conclude the jury is at an impasse. There is a manifest necessity for a mistrial. There is
very
nothing more to be
confusing.
done here. And in fact, in her order denying the defendant's motion to dismiss, the judge did say a mistrial was inevitable.
You can't find consent, right? If you don't ask, the consent is out the window, isn't it?
I don't agree, Your Honor.
Really?
Consent through the lack of an objection here.
Even the burden of proof is on the Commonwealth. There's no opportunity whatsoever for the defense counsel to raise anything. I get manifest, you may have manifest necessity, but I don't see how you can get consent when they haven't been consulted in any way.
They were consulted in response to the first 2 notes. And what was the defendant's response to those notes? It was to argue in favor of due and thorough deliberation and accelerate the process at every step toward a mistrial.
But pushing towards a verdict is different from, that's different. I mean, they want a verdict. Because they want Tui Rodriguez doesn't mean they've consented to a mistrial.
Even so, Your Honor, they had opportunity.
Good morning.
While waiting for the jury to enter the room. 30
Had a
seconds
big
is ample
night,
time
huh?
to at least ask, may we be heard at sidebar, Your Honor, after being informed that the jury's in the
How
house.
so?
They could have brought the issue up again during the
Election?
scheduling conference after
Yeah,
the
I
jury
know that.
goes to the jury room, and even after
Yay.
that, they still could have brought it up. And we cited one brief Fuentes as an example of where
Look at my braid.
lodged an objection after the fact,
Looks
after
good.
the jury had been excused to the jury room.
What
and
time do you
counsel
have to be
could
up?
consider Counsel's arguments.
Like
And I
15
think,
minutes.
given the defendant's
I'm
response
sorry, babe.
to
I
the
didn't mean to
prior
wake you
notice,
up.
it being clear what the defendant was
I wanted to tell you I
advocating
love you and I
and
hope
at
you
the
have a
point of the
great
third
day.
note, it being unavoidable based on manifest necessity to declare a mistrial.
All right, I'll let you
Absence of
go.
an objection here, even asking to be heard, Your Honor, indicates consent.
Oh, I didn't go to sleep until
You might
3:30.
have, I know it probably is in
And
your
I got
brief,
up
but what's
at-
your best case for that?
I had about 3 hours sleep.
This case is closer to Pellegrin, Your Honor, and very different than Horrigan.
So you,
So as
you-
between the two,
I'll
certainly
talk to you later.
where there is something abrupt that happens that is inconsistent with the way defendant has conducted him or herself, the approach that they have taken during the trial, it would be difficult to find consent. Horrigan is an example of that.
Bama
The judge comes in,
Green.
abruptly announces the
Ice.
trial judge is unable to preside.
Sorry, I was on the phone with my daughter.
There was no indication there that, the defendant was in agreement with that.
This is
Here,
good. People should
Again,
be
where you
watching.
have the defendant advocating for the result of a mistrial, the ultimate conclusion of it, when it is then ultimately declared to not.
How do you know the defendant is advocating for a mistrial as opposed to pushing a verdict?
Because, Your Honor, not just what they argue, but what they argue.
Because TUI, there's two results of TUI. It's either a verdict or it's a mistrial, and it pushes the jury to its extreme. So when you say that they're advocating for a mistrial, they could have been just as well advocating the jury for that final push. As the TUI Rodriguez instruction says, you need to check yourself. One side has the burden of proof. It's very favorable in some instances to a defendant. So how can you stand up here and say that they were pushing for a mistrial?
Perhaps as to just TUI Rodriguez, although it's a practical matter, as Justice George has pointed out, experienced defense counsel understand that there's not going to be a mistrial before that instruction has been given, or very likely. You could set that aside, Your Honor.
Well, I think experience.
No, don't. You said it.
You're most likely not going to get further deliberations, but counsel also know that it could very well, it's a flip of a coin. It could be a verdict or it could be a mistrial.
Right. On top of that, Your Honor, I would point to, in response to the first note, the Commonwealth argued against a finding of due and thorough deliberation. Hasn't been enough time, let the jury continue to deliberate. Already at that point, the defendant was prepared to argue there's been due and thorough deliberation. I think the exact quote is, "We believe there's been sufficient time." Disagreed with the Commonwealth's reading of the note from the juror that there might still be the possibility of reaching a unanimous verdict, arguing they'd already exhausted all manner of compromise, all manner of persuasion. So, and then again, in response to the second note, again argued there's been due and thorough deliberation. Those arguments are pushing to the point where 234A 68C is triggered, and the jury cannot continue to deliberate, and a mistrial will have to be declared unless they consent to further deliberation.
I think it's safe to say that they were pushing for a TUI instruction, correct?
Yes, they asked for that as well in response to both notes, Your Honor.
Do you need consent in order to win?
No, Your Honor, there was manifest necessity for the declaration of the mistrial here.
And so absent the consent, you can just, you think the manifest necessity existed?
Yes, I don't think that the judge abused her discretion in declaring a mistrial for manifest necessity based on the jury deadlock in this case for the reasons that we have discussed and were discussed.
Well, but counsel, we also have, and not necessarily in this context, but we have in cases where there are evidentiary issues where we have found that the trial judge abused their discretion when they didn't utilize something that they could have. And so in record here where there, again, it's not necessarily prescriptive, but there's 27B that says may, there's other things that could have been done short of declaring a mistrial. Is there could be an abuse of discretion because there's nothing to suggest that she went through the progression of what she could have done short of
Okay. In the Karen Reed trial, the jury came back 3 times, well, 2 times deadlocked, and they were given the Rodriguez mandate, or whatever that is, meaning you need to go back one more time and double check yourselves, meaning one more time. And they came back and they said they were deadlocked, but they were only on deadlock. There were what, 3 charges? And the first one is weird, but they were 1 and 3, the first and the third. I can't remember what those were. Murder and something with alcohol with the vehicle, where they had already agreed she was not guilty. But on the second charge, they were deadlocked. And when they came back, the judge abruptly called a mistrial, dismissed them, done. And so the defense, i.e. Karen Reed and her attorneys, are saying, well, let me go back. Over the next 30 days or so, jurors heard what happened in the courtroom after everything was all said and done, and wrote letters stating that it was not 100% mistrial, that on count 1 and 3, she was found not guilty. And so long story short, The defense has requested that the prosecution not be allowed to retry her on all 3 counts again because they feel that would be double jeopardy. They're asking the Supreme Court of Maine to have the judge go back and voir dire the jurors that were there and to find out if in fact they did find her not guilty on counts 1 and 3. And if that's the case, they're wanting the new trial that's getting ready to start, well, was supposed to in January, but may not start till March, to only be for the charge of the second or the lesser. That's the best I can describe it right now. This case is got so many twists and turns, it's unreal. But I have to say, I'm really surprised we don't have more people watching this. This is a very rare look into what happens in this situation. They're not televised very often. What's wrong with voir diring the jury? It depends on how they're voir dired. That is part of the issue. If you come and say, if you voir dire them and they say on count 1, was it a unanimous guilty or not guilty? And all of them say not guilty. 2, were you deadlocked or was it whatever? Count 1, we were dead. Count 1, unanimous, not guilty. Count 2, deadlocked. Count 3, was it unanimous, not guilty? If they all come back and say that, then the defense is wanting them to only retry her on the second charge. But if the voir dire goes into more detail as to how many votes were for, how many votes were against on count 2, or ask any questions that would lead to that kind of answer, would not be appropriate. I'm not in my best of, my brain hasn't woke up yet. Honestly, I had 3 hours sleep last night.
Declaring a mistrial, which directly goes to not giving defense counsel an opportunity to say, hey, we've got all our heads in the courtroom. Let's all collectively
The
think
defense
about
did
this.
not get an
And perhaps we
opportunity
can all
to
come
object, is
to
what they're
some
saying.
some other vertical other than declaring mistrial.
Yeah, and I think it's clear from the judge's order that she was cognizant of at the time of these countervailing considerations, looking to the jury's notes, the lack of any indication of agreement on the charges, balanced against the risk of coercion, the defendant's trial strategy, and the fact that the defendant had not been advocating for the judge to do something more. I think it's clear that the judge was aware of these considerations and balanced them in a way that was not an abuse of discretion. Might a different judge have reached a different outcome here? Perhaps. But the judge's determination here, which is owed some deference, if not an abuse of
People
discretion,
think
is not
also
outside the range of
that there's a
reasonable
connection
outcome,
with the
given
judge
jury's notes
and
these
this
other
trial.
considerations, Your
They
Honor.
You
call
don't
her
think it would have
Auntie
been
Bev.
coercive to say, come on, jury, I know you say that you're exhausted, that any further deliberations would force us to compromise these deeply held beliefs. But did you reach a verdict on count 1?
I do think that would be extremely coercive, Your Honor, yes. And I would point the court to footnote 5 in Ray versus Commonwealth, where this court said or noted, there may be a prevailing practice among federal courts about inquiring individually of jurors as to whether they're truly deadlocked or perhaps further inquiry. But that is not the prevailing practice here in Massachusetts, and it's not an encouraged practice, particularly because of the risk of coercion.
I take it Rule 27 doesn't, there's no discussion of Rule 27 at any point during the deliberations or sort of preparing for the deliberations, right? When we read through this whole record, we're not going to find any indication it was on anyone's mind, right?
Correct.
But so I see your point on the note is so compelling that they've worked this to the end. But the problem comes when we get this new information that's somewhat inconsistent with that they've, I mean, the key sentence, some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails. Then we get this motion for a new trial with 4 or 5 jurors saying that's not the case, right? That's the troubling part. What should happen at that point?
Yeah, and I do want to make sure I get to this, Your Honor. The alleged agreement reflected in those statements is not an acquittal. It lacks finality of a verdict, really for 2 reasons. One is the reason that's already.
I get that, but I'm just trying to figure out what should the judge do at that point? Because they're arguing, okay, you have some follow-up obligation here. Is there no obligation whatsoever, I guess?
No, and we argued below, actually, Your Honor, that it's not reliable or competent evidence because it goes to the substance of the jury's deliberations and is being used to try and impeach the declaration of the mistrial based on the jury's notes.
Accepts. The judge makes a finding that she finds them credible for the purposes of this motion, right? So she doesn't say they're unreliable, but rather accepts their reliability and then concludes that nonetheless that she can't inquire here without invading deliberations. It's different from reliability. She's given up the reliability point, right? She's made a finding that I accept for these purposes that those 4 jurors or 5 jurors
Correct.
are credible, right? So it's not a reliability issue that you can rely on, right?
Correct, but the judge also correctly or properly ruled that it would not be appropriate to conduct some sort of post-trial inquiry at this point for a number of reasons. One, this jury, a mistrial was declared, this jury was discharged, they've now been discharged for 4 months. They have no power or authority at this point to come back and render a de facto verdict.
Well, the request is to inquire of them, which we said you can do in Fiddler and McGowan et al., right?
But not to get into their deliberations.
Right, you said that, you can't bring this jury back. You can bring them back for post-verdict inquiry.
Well, it's one.
Under the guidance of Fiddler, et cetera, right?
It's one thing, Your Honor, to bring a jury back and inquire as to extraneous influences to determine whether a verdict that was returned and affirmed may have been the product of other than a fair and impartial jury. It's quite another to bring a jury back to essentially construct a verdict that was never
What Mr.
returned.
Weinberg argues is what we protected are the Sixth Amendment rights to a fair trial, but he says we should expand our law, as I understand him, to include the Fifth Amendment right and double jeopardy protections as well. What's your response to that? Why not?
I agree with the reasoning of the appeals court in De Benedetto that it can't simply be the fact that it implicates a core constitutional right to allow for this sort of inquiry. And here, unlike
Why not? Why is the Fifth Amendment any lesser of a right than the Sixth?
it's not that it's any lesser of a right, Your Honor, but although it is different than the Sixth in that here there's a balance of 2 competing public policy considerations. It's not simply the defendant's right, there's the public's interest and right as well. So it is different than, for example, the Sixth Amendment right.
Well, doesn't the public have an interest in finding out the truth of what the jury decided?
They have an interest in a just judgment that is in fact a final outcome or final verdict here. But setting aside whether expanding it might be appropriate, it cannot be done in this case without getting into the substance of the deliberations. And I think my brother revealed that under questioning. There are several issues with it. One is, again, this jury has been discharged now for more than 4 months and has been subject to extraneous influences, potentially including harassment.
We've
or
sent
threats.
back jurors on race. I can't remember how many years. It was like a decade later or something. Timing's not going to be a winner for you, is it? It has to be.
No, that by itself, Your Honor, is not a reason not to do it. I'm raising it as an additional consideration or concern here. But there are others as well, which is it's not simply a matter of bringing a jury back and trying to ask them a yes or no question. That's not how juries reach verdicts. We ask them to engage in group decision-making, collective discussion, review of the evidence.
But they had reached decision.
Is guided, and we always say to the jurors, and we tell the trial judges, you have to instruct the jurors, do not tell me about the contents of your deliberations, answer this specific limited question. And the limited question posed by the defense, and I think in the ACLU brief, is did you reach a verdict essentially on counts 1 and 3, or was it an acquittal? Right?
I don't know that that was the specific question they proposed, but I understand, I take your honor's point.
I mean, however
Yeah.
they phrase it, it's a limited yes/no question.
Yes, and my point is that that's an artificial inquiry. Or take, for example, did you
have you reached a verdict? That in and of itself is a standard question, right? That can't be crossing the line, right? Or is it?
In count 1, did you reach a verdict? In count 2,
I want to
count
re-emphasize
3,
the point that was raised earlier.
count Dracula.
Imagine a juror had tentatively agreed to find not guilty on a particular charge, but that was subject to further deliberation or consideration. Maybe the juror wanted to see what happened with the other charges. You now bring the jurors back and you simply ask them, I don't want to hear anything else. I just want a yes or no. It doesn't give that juror any opportunity to explain that their agreement was tentative at that point. And so it's an artificial exercise.
Yes,
to say,
but I'm glad they're being just as hard on him.
Justice George asked brother counsel about Bluford. Is Bluford the answer for you, that that's what Chief Justice Roberts was saying in Bluford, that it's always tentative? Or is it's only in lesser includeds that works? Because I asked Mr. Weinberg, is there a federal case right on point that we can look to? You at least have Bluford. Is Bluford controlling? And it's the Supreme Court.
I would argue that it is. I actually take it one step farther, which is not only is there the concern that was raised in Bluford that the perceived agreement or unanimity here may have been a product of a very early discussion subject to further deliberation, but jurors are free to change their mind and change their vote right up until the verdict is affirmed and recorded. They could vote guilty, walk into the courtroom, and at that point change their mind and say, you know what, I think the defendant is not guilty. So even if, like counsel wants to argue, this was a final vote, this was a final decision, you still can't rule out the possibility that any juror was free to change their mind had they been required to go through the full exercise of rendering and affirming a verdict.
Can I ask, is their argument what Justice Sotomayor wrote in dissent in Bluford, or is the different?
To characterize counsel's argument, I think that they are relying on that for the notion of there being an acquittal in substance, not form. Although if you look at the cases Justice Sotomayor cited for that proposition, they're all cases involving judicial rulings. They're not jury determinations. I'm not aware of any federal authority that supports the proposition that there can be an acquittal in substance but not form, or I guess more to the point, says that a state cannot impose the requirement that a verdict be affirmed and recorded. I think, if anything, Bluford acknowledges that that could be a perfectly legitimate requirement where it said, take the defendant's argument here on its own terms. It wasn't a final result, quite apart from the requirement to render a verdict or a judgment. So I think Bluford does support our case, Your Honor. I just do want to emphasize that it's not only just the possibility that there could be a change of mind during the deliberations itself, but even after that.
Bluford limited to lesser included, or is Bluford broader than a lesser included opinion?
I don't read it that way, Your Honor. No, I read it as the general proposition that there are multiple charges, whether they're lesser included or not. Jurors remain free to go back and revisit a prior vote. In fact, I think the court said that although Arkansas was an acquittal first jurisdiction, nonetheless, the jury remained free to go back and revisit a prior vote because that's what jurors do. And it wasn't inconsistent with the instructions. I want to emphasize one other point, which is at most, what we're talking about here with these juror statements is a snapshot of the jurors' deliberations, but you cannot short circuit the verdict requirement and rely merely on such a snapshot. And it's important because it protects defendants too. You could imagine a different scenario where a juror comes forward and says, notwithstanding the declaration of a mistrial, we all took a vote and we found the defendant guilty of murder. If the Commonwealth were to come forward and say, effect should be given to that vote, there can't be any serious doubt the defendant, whether in this case or in a future case, would argue that is not a valid verdict. and shouldn't be given any consideration. Unless your honors have any other questions, Commonwealth would ask the defendant's petition be denied.
Okay, thank you very much.
Thank you.
Court, all rise, please.
Wow. What do you think? The judge should have asked the question.
Please exit the courtroom.
Are we in recess? So we're not going to get an answer today. But I want to watch the courtroom. Or not. Okay. That be done. Oh my gosh. Is the state mad because the jurors found her not guilty on count 1 and 3? I think they were a little surprised. I think that they, I don't know how did I miss something? There we go. Sorry. I've never done my hair this way. It was a happy accident. Recently. So anyway, it's going to be interesting to find out what they do. And I think it's going to impact whether or not I know they're wanting to, both sides want to delay the January trial to March because there's supposedly some new evidence, and both sides are looking at that evidence. So I don't know. We'll see. So it's going to be very, very interesting, in my humble opinion, to see what they actually bring forth. I don't know how long it's going to take. This I've never seen before. I've never witnessed this before. I don't know why my mic is slow. How's the sound on your side? Because on my monitor, it looks low. But then again, I am setting up for our next live. We are going to be hopping over to the South Carolina versus Lewis, where the gentleman's wife was burned and ended up passing away from those horrible, horrible wounds. So I have an echo. Do I now? Is there still an echo? Why do I have an echo? I don't know. Why do I have an echo? Okay. So what I'm going to do is we are going to go live over on the other stream. It should teleport you over, and where now you hear it. Okay, maybe when I teleport you, it'll stop. So I'm going live here. I'm ending live here. I'll see you on this side of the screen. And go live. Guys, thanks for joining for the Karen Read.
Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.